So let's give a big round of applause to
Thank you, Tom. Thank you for having me out on Saturday. Thanks for coming out to listen to what I've got to say. Tom kind of laid out the fundamentals of intellectual property. I've got a lot of slides on that, so instead of repeating it, I'm going to kind of deviate just a little bit from what I had planned on covering. But let me talk a little bit about the Patent and Trademark Office first. So over the last 200 years, the Patent and Trademark Office has always been out in the Washington, D.C. area. It was in the Beltway, it stayed there, and there really wasn't an intention on expanding the Patent and Trademark Office outside of that area until, yeah. Is that a little better? All right, so everybody that's watching the video, you just missed out on the best part. So the Patent and Trademark Office has always been in Washington, D.C. We ended up several years ago having a large backlog in our patent applications. And when President Obama took office, hired a new director of the Patent and Trademark Office, the idea was we need to bring that backlog down. It's not good for the country, it's not good for innovators to have a large backlog of patent applications that are taking years to examine. So the best way to get rid of a backlog is to increase your employee base. So we actively started hiring lots of examiners, specifically in the areas where we had the largest backlog. But you can only hire so many examiners in Washington, D.C. that want to live, commute in, cost of living. So we needed to think outside the box. One of them was to have telecommuting, so we could have examiners live in other parts of the country and work from their homes. So we've probably, out of the 8,500 examiners we have today, close to half of them work out of their house. The other idea was, let's have some offices where we can hire examiners to help with the backlog outside of Washington, D.C. So they opened an office in Detroit. And the reason Detroit was picked, many reasons Detroit was picked, but one of them was it had a lot of engineers that were unemployed or underemployed there that we could use, offer jobs as examiners. So the Patent and Trademark Office opened the first regional office in Detroit with the intention of hiring people. Then Congress, as they're working through the Patent Reform Acts that they've been working on for the last 10 plus years, authorized in the American Invents Act, which was signed into law 3 years ago, additional patent offices with the intent of further hiring examiners and also specifically connecting the innovative community with the Patent and Trademark Office, a closer relationship throughout the country. So they authorized additional offices. We just opened the Denver office. I'm proud to say that I moved here from Micron. I was the chief patent counsel at Micron, and by the way, as we were asking questions, feel free to ask me issues about what it's like to manage 20,000 patent portfolio for a large company and issues like that. I'm happy to talk about that outside of my current role. But we're the first Patent and Trademark Office west of the Mississippi ever. So happy to say we opened the office officially on June 30th, downtown Denver on Stout Street in the Rogers Federal Building. This spring, we're going to open an office in out in Silicon Valley in San Jose. We're in the process of remodeling the building right now. It should open in stages, but we should hire our first group of examiners by early spring. Followed that up, we're going to have an office in Dallas, should be by next fall. So by this time next year, we'll have all of the offices up and running and busy hiring employees. With regard to our office here, our first employees started with me on July 15th of this year. Those examiners that we hired, I should say our first employees, because we had 9 judges already. Judges had been here for the last year in a temporary facility, but so I guess technically they were our first employees, but they beat us. The first examiners started on July 15th, and they're experienced, yes?
I was just wondering, how many examiners do you have now, and how many are you
just going to get to the quantity. No, that's okay. The question was, how many do we have and how many are we going to get? The total that we're going to have, we've got space for 100 new examiners, space for 10 transfer examiners. We have space for 20 judges, and then the admin side. And that pretty much fills up our physical space we have right now. The first groups that we hired for examiners were IP experienced. A lot of them were either attorneys, patent attorneys, or former patent examiners that wanted to return to the office now that we're in a space where they like to live. So we only have a 5-week training for them to get them up and running on being patent examiners. We've had 2 classes so far that have graduated. My 3rd class just started last Monday. They're what we would call entry level, basically. New. They have a 4-month training period, so it's much more extensive training for those examiners. We have 75 people in the office already, so we're well on our way to reaching that 130. I would expect we get some more judges soon. With regard to the physical space, what do we have to offer you as the public? You can come in. We have a search room with 4 terminals that are connected to the same databases that our examiners are connected with. So if you're a small inventor and want to come down and have a little help even with doing a patent search, that is available. For those of you that have applications already pending with the patent office and are in examination, we have an examiner interview room, which is connected webcast, so you can have a video conference with your examiner, even if they're working in Miami or in Seattle or wherever they are. They can, through their computer system, can reserve our room and connect to you. And I highly encourage that if you have applications pending to use it. It will move your application along. We have a hearing room for our PTAB judges, our Patent Trial and Appeal Board judges. I can touch a little bit more on what kind of trials are available with the American Invents Act that created several post-grant proceedings that if your patent application or your patent ends up in that, you can have the hearing here in Denver. So Tom covered the basics, and I'll go through this, but feel free to interrupt me. I'd rather this be a little bit providing information that you want to know instead of pre-designed slides. But Tom talked about patents. So the patent operation, or the patent system, is what most of us think of it as a utility patent. It's a patent to cover the utilitarian function of your invention. We also have design patents, which cover the ornamental design, so industrial design. If your company is making products that are primarily differentiated from others because of its ornamental design, then you're going to want to look at some design patents to cover that. Copyrights, examples, obviously, are books, photos. Tom, again, did a good job of that. Trade secret actually, as Tom was saying, is very important. When I was in the corporate world, I had to make that decision between, am I going to file a patent application on this, or am I going to keep it a trade secret? And I wasn't thinking so much about the secrets in a business like your customer list and your employee list and that, but I'm thinking more about, how are we depositing metal onto the semiconductor? What are the internal methods in which we employed to create that invention? Now, I could get a patent on that, but if I do, it's going to become public, and I'm going to basically teach my competitors some of my secrets. But to have a trade secret, you have to have safeguards in place, and it can't be reverse engineered. If it is reverse engineered, independently invented, then it's no longer your secret, and you no longer have any rights in it. But for those of us that were doing a lot of manufacturing in foreign countries, it became a real issue. We're sharing our secrets with our employees there. Sometimes the safeguards aren't so good, and they'll sneak out the back door. So I had to kind of balance between what I wanted to patent, what I wanted to keep a trade secret, and then also, if we got into foreign jurisdictions, and we'll talk about patenting in foreign jurisdictions, enforcing it in different countries, the laws are different. Not only what you have to prove and what your damages are, but what you're able to discover from others. So in the US, we've got a pretty robust discovery system where we can have our lawyers discover what our competitors are doing, get their secrets, if you will. In most jurisdictions, you can't do that outside the US. So it becomes difficult to find out if they are actually adjusting their machines in the way that you think they're adjusting them. So you may not be able to enforce patents on those. Trademarks, I think, were covered fairly in depth. So here's, and we use an old example, and here's an old Nokia phone. Being in the government, we tend to look at old things instead of new, just to keep us from getting in trouble. So this is an old phone, but it's a slide that we use to kind of explain all the different kinds of intellectual property that you might have in one device. So you've got trademarks on the name, trademarks on the product itself, maybe some software that you've embedded into the device could have trademark names to it. The patents on it, I'll skip kind of the patents a little bit. We'll get into that in a little more detail, but certainly covers methods. It covers the components that are inside of it and the way it would operate. Copyright on your proprietary code, maybe on the ringtone. Trade secrets we don't know. Designs, there's been a lot of, I think, resurgence in design patents recently, and part of it is because of the Apple-Samsung litigation and Apple getting a large jury damages out of Samsung based on the shape of their phone and their design patents. And some people had thought that design patents had kind of gone down. We actually have seen a resurgence and increase this year in design patents at the Patent and Trademark Office, applications that is. So I think there's more focus on that. And in addition, at least it's my speculation, that we're going to see issues with the easy replication of designs through 3D printing and the proliferation of that. I think it makes it a lot easier for somebody, if you come out with a design, to quickly scan it and then start reproducing it, where before, somebody would have to actually cut a mold and then start manufacturing. You had some lead time before somebody would copy it. Now I think it's going to proliferate fast. Yes, Tom? Your question is, does money ever really change hands when you've got two big parties fighting it out like Apple and Samsung? I can't speak to that because I can't speak specifically to that case because I don't know the details. I'll just talk in general terms that, and Tom earlier had been talking a little bit about the big guy squashing the little guy and the way it goes about. Yes, oftentimes there is a lengthy appeal process, especially in patent litigation recently, because the law seems to keep changing underneath our feet. So you might get a federal district court decision that would award you, say, $1 billion. That obviously is going to be appealed to the appeals court, which would be the federal circuit. The Court of Appeals for the Federal Circuit has exclusive jurisdiction over the patent trials. A lot of things could be litigated at the appeals court, whether there should have been certain evidence entered or not, and things to have to do with the trial. But on top of that, they're going to review the findings of the court based on the enforceability and interpretation of the patent, which could also get reversed back. Once that's done, if it gets reversed for further decision and then back to the federal circuit, then it can be appealed to the Supreme Court. And the Supreme Court's been very active in the last few years on patent-related cases. For example, just recently, the Alice decision with regard to patenting, some people would say software. The Supreme Court came back and basically said abstract ideas. through that entire process, there's negotiation between the two parties to try and figure out whether they're going to exchange money or not. So ultimately, it can end up in exchanging of money, but often it's a business decision throughout the process to balance your risk and reward and strike some kind of a deal. Yes, sir.
So on design-related patents, because 3D printing is going to revolutionize all that, is it going to be the case that patents will be harder to get because they're easier to have the intellectual property duplicated?
The question is with the prevalence of 3D printing and the easy ways to reproduce something, is that going to make patents harder to get? No. To obtain a patent, so you've got utility patents, you've got provisional patents, which is really a process to save your point in time, and you've got design patents, but all of them have to, design and utility patents have to meet the statutory requirements for a patent, which is it has to be useful, which is usually a low bar to overcome. It has to be within the statutorily allowed areas of having a patent, and we call that 101, but so it can't be a mathematical equation or an abstract idea. But it has to be new, so it's not known before you filed, and it has to be non-obvious. Non-obvious is a difficult, I could give a whole lecture on non-obviousness, but basically what it is, when we go through the examination at the Patent and Trademark Office, our examiners are looking at your invention and doing a prior art search to see what has already been published and known. If we happen to find the exact thing that you're claiming, then it's not new, and so we're going to give you a rejection, that a 102 style rejection, as we call it, which it basically says your invention was already disclosed, and here it is. If it's non-obvious, what we will end up doing is finding several documents that are each, for example, teach a part of your invention, with some teaching inside of those that say combine these, and you would end up with that. Now, we never find a series of documents that are perfect in that regard. What you will find is, for example, you've got a patent that claims A, B, and C. We have a document that includes elements A and B, but it has D, and so it's not the same. But we find another document that says it's known that you could substitute C for D. Combine those two, and we've got A, B, and C. To one skilled in the art, they would realize that we take D out and put C in because we got. So that's kind of what obviousness is when we're talking about the law. So will it become harder to get a patent because somebody could easily replicate? No. You still meet the statutory requirements, you're going to get a patent regardless of what would happen afterwards. The caveat that I'll put out there is, at the moment, you can keep somebody from making, using, or selling your patented invention. So if you had a design patent and I started a molding company down the street and was making knockoff products of yours and selling, you could come to me and shut me down. With 3D printing, it becomes a little more difficult. If I scan your device and have a website where people could come and for 50 cents get the 3D data and then have it printed out at a local 3D printer, I'm not making, using, or selling. I'm just selling data that represents your device. The actual infringer is the person that prints it. So that's a whole new issue, and Congress hasn't even talked about that one yet. I've got a question out front. So the question is, with a lot of the patent litigation, there are parts of the patent litigation where the government is involved, and who's taking care of that? We are. If there's a case, for example, in front of the Supreme Court, and the Patent and Trademark Office, the Commerce Department have an interest in the outcome of that decision. We obviously do, because we want to make sure that the public's interest is represented. Then the solicitor's office within the patent office is going to participate in that. So part of our legal team at the Patent and Trademark Office is trying to be involved in how some of the policy is created through decisions in the court. So we'll file an amicus brief or participate in it. As far as the judicial component of it, for patent trials, you've got a couple of paths. One path would be the traditional judicial process through the federal courts. So if I have a patent and you're infringing it, I can take you to federal district court and seek damages or an injunction to keep you from infringing on that. There's also some judicial proceedings within the Patent and Trademark Office. We have judges. We actually have 200 judges at the Patent and Trademark Office right now and growing. But what they had done prior to the change in the law from the American Invents Act was deal with appeals from the process. So if you're rejected by a patent examiner, you could appeal it, and they would review that and make a decision. They would also deal with interferences, which really don't exist anymore. But now they deal with post-issuance of your patent trials. So the American Invents Act created inter partes review, which is, if I sued you in district court, you now can petition the patent office to have a trial to determine the validity of my patent. And that's guaranteed to happen within 12 months. And it's much cheaper than going through many years of litigation costing millions. So the patent PTAB judges will handle those cases. Also, as part of the American Invents Act, there's a new proceeding called a post-grant review. So if my patent issues and you're, as a competitor, looking at it saying, that's not right, I know that that patent shouldn't have issued, you have 9 months that you can file a petition with the patent office to have a trial on that to determine whether that patent should or shouldn't have issued. So those kind of trials happen within the Patent and Trademark Office, and obviously we covered the cost of the legal or the judicial side of that as part of our budgets.
Was that true, or did that make it through? Or?
There's always been the ability, the discretion of district court judges to shift the cost of litigation based on things that happen in the trial. So if there's one party who is not behaving well, let's say, or brings frivolous lawsuit, there's always been that discretion. There's been some recent court cases where that have gone up on appeal where the Supreme Court has said, you know, you can fee shift for, it does not have to be as high a hurdle. So there is a movement going to try to have a kind of a loser pays system that's a little bit more like some of the international or European. You're starting to get outside of my area of expertise to get into that. I'll try to restate the question for the video, but the question sounds like, in crowded art areas where there's a lot of patents already, and there's perhaps questions about the validity of some of those patents. If you filed an application that proved I'm not sure how to restate that. If you file an application that fell within that area but had strong scientific proof behind it, what happens basically in the office? The first step probably would be that you would, if you're trying to claim something that's already been claimed in a patent, it would probably be rejected first off. If you're challenging the validity of those patents because the underlying science behind the earlier patents was faulty, or lack of science, you would basically have to go through the process with the examiner, and perhaps even go farther than that, to prove that what was taught by the earlier patents was faulty, it was wrong. That one skilled in the art, looking at that, would have realized that result is not what would have happened. It becomes very murky. I can't give an easy answer without the facts of it. But you do run into prior art that when you pull it apart, you realize that they kind of went from step A to step C, and some miraculous thing happened at step B that they forgot to tell the patent office. And they claim the result of this process, but we unfortunately don't have the expertise to know that they jumped over a step.
Because there's no there, and we're bringing that to the conversation.
Yes, so you would have a difficult time probably getting a patent on yours. You would be easily knocking the others out perhaps and making them invalid so that they're not enforced against you. But if you're just showing the science behind it as opposed to inventing something that changed the flow of things. So if I guess what I'm trying to say is you've got better evidence to knock their patent out, but that doesn't necessarily make you patentable over theirs. If you, however, had invented a step along the way where that step that they just kind of pretended happened, you actually solved that problem, then you could get a patent on that step or the series, including that step that you invented. Yes. So the question is with the first inventor to file system that we have shifted to currently, kind of creates, as Tom was saying earlier, a race to the patent office. And if the race is happening and two people get to the patent office, but their inventions are a little bit different, what happens? It's a good question. They would probably both be entitled to their patent, assuming that their inventions were non-obvious over the prior art. But if you were second to the patent office and the person that beat you has prior art to yours, and yours is obvious in light of theirs, then you have a harder time overcoming their patent application and the other known prior art. Tom was right when he was explaining that with the shift now, it is more of a harmony with the rest of the world. You do have to deal with a few issues that you can publish, and he said it was kind of a first to publish, but be careful. If you publish or disclose your invention today, yes, you have 12 months, if you will, to file an application on it, and nobody can take that publication and file a patent application on it. But if you teach in your publication A, B, and C, somebody looks at it and goes, hey, we can add D to it, they can file a patent application on A, B, C, and D. You still have the right to A, B, and C, but they've beat you to the patent office on an improvement to it. So be careful. The law basically says that they can't take your idea or derive it from you. So if you're working with a supplier and then they run off and file a patent application on it, they can't derive it from you. That still belongs to you. But if you make it public and somebody improves on it or finds a weakness in it that they want to, they can still file on that. So I give you hesitation to say that don't completely rely on that. Talk to an attorney or file a provisional application to secure yourself in that. And also a warning for those of you that are thinking about using crowdsourcing, crowdfunding to raise money. At least most of the ones that I've looked at, there's usually an offer for sale in there. You say, I want to build this device, give me money, and by the way, anybody that gives more than $25, you get one free. Well, that's an offer for sale, and that's going to start your public disclosure and your 12-month date. So be careful. There's no precedent out there right now to have had a court decision say what you have lost your rights because of that. But if you were thinking about going international, that kind of thing is going to eliminate your international rights. Yes?
Could you comment on some of the kind of format policies on like a provisional patent? I understand you don't need necessarily an attorney to file a provisional.
So I pulled this up just kind of show a little of that path. No, that's okay. The question was, go a little detail about provisional patents. So a provisional application is an application you would file with the Patent and Trademark Office that we don't examine. We'll record it for you. I mean, you file it with us. We don't examine it other than the basics to see whether you've checked off the boxes of the things that you're supposed to have. But we're not going to determine whether you've enabled your invention in there. We're not going to determine whether you're entitled to a patent application on it. You could file a series of provisionals over the course of a 12-month period, let's say, where you've got your invention today and then next week you get your prototype back and you tested it and you improved it. You could file another provisional and another provisional. Within that 12 months, you can combine all of those provisionals into one utility application that claims the benefit of time on all of those and covers all that technology into one utility application. My warning to you would be that while you can file a provisional on your own, you should do some good research. We've got fantastic data at the uspto.gov. You can go in. We've got a lot of information to explain what you should be doing and thinking about, because you want to make sure that the provisional application really adequately describes your invention and gives you the foundation. Because if you file that non-provisional claiming priority to if you file the non-provisional claiming priority to the provisional and the provisional was just a scratch on a napkin, it really doesn't describe the invention or provide enough basis that you would really be entitled to that date. All that new material that you put in the non-provisional gets the date that you filed the non-provisional. I see our next speakers, and I'm not sure how much time I've got, but I wanted to point out a few things. For those in the audience, there is a pro bono program in Colorado, and that was part of the initiatives that were put together from the president. That connects small applicants. There's a financial limitation, I think 3 times the federal poverty level for the household and some other metrics, but that connects independent inventors with volunteer lawyers in Colorado, and that's, you can find that through our website. Either pull up our website and take a look for Pro Se, or you could also search MICASA. The MICASA Resource Center here in Colorado is the one that is connecting those two together. If you file a patent application on your own, you're a Pro Se inventor, Pro Se applicant, so you're doing it without an attorney. We do have resources at the Patent Office. We've just put together a special team of examiners that will assist and review Pro Se applications. So if you want to step into this realm on your own, you can do that. I don't necessarily recommend that that's the best way, but if you feel like you're experienced enough to go through the patent system without an attorney, there are resources at the Patent Office to help with that too. Yes, Tom. I really don't have a lot of knowledge about patent insurance policies and what they would cover and what they wouldn't cover. I have a lot of speculation on the value of that. I think it's all going to come down to what the contract says that they would cover. Patent litigation, unfortunately, is a very expensive process and very unpredictable. The process of I'm going to deviate a little bit here. The process of obtaining a patent, let me see if I've got a slide here. Okay, so that's a slide on our website. This kind of shows a few of the steps that your application is going to go through, and you can hyperlink into those. And needless to say, it can be very complicated. This one is an oversimplification of it. But you file your patent application with the office, and it will reach its way to an examiner. Unfortunately, there is a delay. It's about 16 months right now between when you file it and when an examiner will pick up the case and start working on it. They'll conduct that examination I was talking about earlier, looking at your application and comparing it to the legal requirements for patenting, doing a prior art search, no, skip that, doing prior art search, and ultimately sending you an office action with the determination of the Patent and Trademark Office to say, your invention is not new because we found it in this reference, or it's non-obvious, etc. And then you have the chance to respond to us, point out to the examiner why the examiner's wrong, they misinterpreted that claim, they didn't understand that prior art, they didn't, the physics behind the prior art aren't what they think it is. And ultimately, you can get allowance on your patent application. Now, there's a lot of subjectiveness in that. So the quality of your application, the quality of the prior art search, the subjective application between your attorney or you and the examiner result in a patent that a lot of the rest of the world is going to look at and say, well, that shouldn't have happened, or that it's too broad. So that's where I'm kind of coming back to on the litigation. There's a lot of unknowns in it, because when you spend tens of thousands of dollars to get patents, but you have millions of dollars in litigation money to be spent, it's a lot easier to knock a patent out with you know, a $500,000 prior art search covering everywhere in the world, versus what the resources of you and the patent office can put forward to examine your application. Yes, is
incorrect, some incorrect wording changes.
at which stage in the process?
At publication, it's noticed.
Oh, so the question is, what happens if your lawyer did a lousy job and you spotted it after your application, 18 months later when your patent application published? Hire another lawyer for malpractice. There's not much from the Patent and Trademark Office standpoint that you can do. You signed off on that application when you filed it. It's one of the requirements that Patent and Trademark has, when office has, when you sign your declaration as an inventor, when you submit that application that your attorney wrote for you, you signed off on the fact that this is my application and my invention.
But what I signed off on was different than what I read that was published that the attorney filed.
From the Patent and Trademark Office, the question is that you know, what you signed off on and what the attorney submitted were different.
There's no substitute for.
The Patent and Trademark Office doesn't know that. We got a document in your signature that says this is what I invented. We put it into the system and it's moving along. If the error is fundamental to your invention and basically ruins your patent application, there's not much you can do. You could refile a new patent application, but you're going to lose that 18 months and all that prior art that came in between. And possibly your public disclosures would have barred you from filing a new application anyway. If it's a simple error, sometimes those can be corrected. I mean, if it's a typographical error, if it's an error in the claims that aren't but the specification remain the same, you can edit the claims on what you're doing. But from our perspective, that's an unfortunate incident between you and your lawyer. There would be discipline that could be done. You could notify the Patent and Trademark Office that your attorney substituted something when they shouldn't have, because that's not proper in front of the Patent and Trademark Office, and they could be disciplined or disbarred for doing that. But as far as saving your patent application, it makes it very difficult to do.
There's no substitute for doing your own homework.
No, but if you read an application, signed off on it, and then they substituted something after your knowing.
But aren't you supposed to prove it after he's made any changes?
Correct, but I'm not sure. That's a lot of hypotheticals on how the process happened. Obviously, having good quality attorney and a good working relationship with them is imperative. I would also suggest that it never hurts to double check. So when they file an application for you, immediately look at what was filed and ensure that it's what you signed off on instead of waiting until publication. But that's a lesson learned after the fact instead of before, unfortunately.
I'm curious as to what the cost is to file a provisional application and non-provisional application.
There are different tiers to filing, the cost of filing. So the question was, what are the costs of filing in patent applications? We have 3 tiers. We have a large entity, which is over 500 employees. We have a small entity, which is under that, and that's 50% of the large entity. So if we think of the large entity as the full cost, a company like I used to work for, we paid the full cost. A smaller startup company is going to fit into the small entity status, and we have a new level called micro entity, and that the requirements are set out, if you go to the website, I hate to point to it, but the fee structure is kind of complex for me to pull out, but we've got a full breakout of the fee structure on the 3 different. The micro entity is really economical, but there are requirements. Again, similar to the pro bono, you can't make more than X amount of money, and you couldn't have filed more than, I don't remember a handful of patents. So it's intended to help the independent garage kind of inventor to be able to get into the system much less expensive. But we're talking hundreds of dollars for a micro entity, low thousand for the small, and several thousand for the large. Kind of in that ballpark.
Do you ramp up as you go, or
Ramp up.
you start at micro and then become larger?
Oh, absolutely. I mean, the question is, as your business grows, can you ramp up? Certainly, if you're an independent inventor right now and you fit into the micro entity status, take advantage of it. If you step outside of that and you hire an employee, your small business starts making money and you step out of that financial, you're going to be in the small. And you have to move to the small. And if you end up being very successful and having 500 employees, you have to go to the large entity. You also have to pay those fees if you license. So if you're a small entity and you file your patent application, but you're successful in getting a large entity to license it, you've just stepped into the large entity. So for further processing with the Patent and Trademark Office, you will now start paying the higher fees because it's been licensed. So you have to pay attention to that as you go through the system. After your patent issues, by the way, there will be maintenance fees that are due. It's something a lot of people don't look at, but 3, 7, and 11 years after your patent issues, you have to pay maintenance fees to the Patent and Trademark Office to keep your patent in force. You could look at it as a tax or a fee, but what the government looks at it is an incentive for you to dedicate your issued patent to the public if it's no longer valuable to you. And those fees go up. I have 5 minutes? Thank you. So I have 5 minutes for a couple more questions. So the question is, if you're in a completely new technology area, what happens with your application at the patent office?
Well, someone I know was told some years ago that his technology was not patentable as a new technology, but it had to be a whole new science, which might entail $10 million plus different scientific institutions involved. It's kind of a big deal because it was different than what the scientific community would accept as fact according to their knowledge base.
Okay, so it's hard to restate the question. Hopefully they'll be able to catch it with my answer. All of our examiners are divided into technology groups within the Patent and Trademark Office based on what we've determined different classifications for the inventions that come to the Patent and Trademark Office. And some of those technology areas are very narrow, and the examiners work in there for years and know it. So there's probably not a technology that would be applied at the Patent and Trademark Office that's not going to fit in one of those categories. Obviously, as technology advances and we add on new classifications, new groups, whether it was, you know, in the software areas or microprocessors or whatever, as they were invented and burgeoned into growing areas, we've added in those. I think that what perhaps you're alluding to is the Patent and Trademark Office might look at an invention submitted and say there is no scientific background to prove what you're saying works. It's a perpetual motion machine. It's a way of teleporting from one place to another. And we would basically say, you're going to have to prove to us what the fundamental physics, or we are not aware of it. We're not aware of it in scientific journals, we're not aware. So that may be what you're referring to as the Patent Office basically coming back and saying, you have to enable your invention so everybody else can replicate it. And we're just not, you didn't describe it in your application, and we don't understand that this exists. We'll give you a patent on it if you can show that it exists. So I'm thinking that might be kind of the area in which you're, that you kind of heard that and say, well, you need to prove the science behind it, and it costs a lot to do that. But I think it's more along the line of, we can't give you a patent on it because you've given us two pieces, and the science behind how to get there just doesn't seem to exist.
Does the science, in order to prove the science, do you rely on what's in the application, or then do you have to go back to the scientific community and see what they accept as?
Well, what would basically happen, and it's difficult to get into details on it because, you know, again, this is a lot of hypothetical, but if you filed an application and the Patent Office came back and said, your specification doesn't teach us how to do what you're trying to claim as your invention, if you, as the applicant, came back and said, well, here's the scientific journals that teach that support what I put in my application, then, you know, the known technologies that were out there show that your patent application was sufficiently detailed to teach one skilled in the art, then you would be okay. If that knowledge in the scientific community doesn't exist at all, and there's nothing to support it, then it needs to be created in the background, and you would need a new application, in essence, once that scientific knowledge is actually established, so that you have a document that would teach somebody how to do it.
So then you would refer to scientific journals, and that means that
you as the
in there first.
Yeah, you as the applicant would, in the examination process, if the examiner said you went from step A to step B and there's no known way to do that, you could point to scientific journals and say it's well known how to get from step A to step B. I didn't need to describe it in my application because all the good physicists know this. But if we say you didn't teach us how to go from step A to step B, and you say, well, that hasn't been invented yet, or there's no scientific proof that can even happen, then we unfortunately say to you that you've told us that you can step into a machine and teleport to this location physically. Tell us how that works. And you say, well, it will work, but the scientific proof's not there yet. We would basically say your application does not teach one skilled in the art how to do that. And until you can teach us, we can't give you a patent on it. One last question. So the question is, what would you as an applicant need to provide to the Patent and Trademark Office to to teach one skilled in the art? What evidence, or what do you need to do in there? There's not really a requirement right now for best mode anymore. And a best mode idea is that you had three ways of doing something. One you knew was the best, and one you knew was substandard, but would get you there, and you would file an application on the substandard so that you didn't teach your competitors the best mode. I still suggest that if you have a best mode, you put it in your application. But what you need to put in there kind of varies depending on the invention, really. You want to show you want somebody to be able, without undue scientific research, to replicate what it is that you're claiming. So you're better off being more inclusive than under-inclusive in what you put in your specification to ensure that nobody's going to accuse you of not putting sufficient support in there that somebody could use the invention that you're setting forth. That's kind of that quid pro quo with the government is, I'm going to teach you, you can build on that, I get an exclusive right to it.
But what if, would somebody get it for something?
The question is if the prevailing, let's talk about the prevailing consumer market is one direction, and you've got something that is much better than that. It costs less, it's more efficient, energy-wise, whatever. From the Patent and Trademark Office standpoint, we're bound to review your application based on the laws as they exist and the prior art that's there. Whether the consumer market likes your idea better than their idea, whether yours is disruptive in the marketplace, unfortunately happens outside of the Patent and Trademark Office. There are secondary considerations. For example, if we reject your patent application as being obvious in light of some references, you could come in with a secondary consideration and show market success or a long-felt need to show that why your invention was not obvious in light of these references. But that's a whole nother talk on that. But it doesn't weigh any with us why your invention would be more marketable or benefit society better than others. We unfortunately are bound by that.
But I'm not speaking to market, I'm speaking to science.
Sure, but it kind of falls into the same regard, whether there's better science on one side than the other, or I hope you understand what I'm saying is that those factors don't necessarily weigh into the examination of patent applications.
So they're a lot more objective than what we understand them to be.
We are, the Patent Office is objective in what we have to do, we're subjective in how we do it. I mean, we're bound by the law on what we're to do, but obviously you've got a human sitting there looking at documents and trying to make that connection. One last question, if it's quick.
Thank you. Real quickly, because that might answer this question, but isn't the strength of the patent reside in the number of citations and the quality of citations under the patent?
So the question really goes to what is a quality application?
Right.
Which the strength of the application is not necessarily based on the number of citations. That might be one metric that you could look at to say, well, I mean, in theory, the examiners looked at millions of documents when they go through their searching. They've focused on a handful that have filtered down to applicability to the invention. So whether you listed the million that you started with in the database or the handful that you cited, either as the applicant citing to the office or the office citing to the applicant, is not really a true measure of quality. It certainly shows that these pieces of prior art that are relatively close to your invention were considered and as opposed to the group that wasn't really thoroughly considered. A quality of a patent really, there's so many things that go into it, from the quality of the attorney that wrote it for you to the quality of the art that was looked at, the thoroughness of it, the skill level of the people that are working on it. A patent has a set of claims in it And it's very similar, it's an intellectual property document. It's a document to cover your intellectual property. And it has claims that are written to your invention. And I like to say it's the same, or it's analogous to the deed on your house, which has a physical description of the boundary of your real property. It tells you start here and go 300 feet that way. And so the claims in a patent are the same for the intellectual property. You file an application with the patent office and you want to claim this much intellectual property. But there's some art out here, so then we get you to narrow it, and then we show a piece of art here and you narrow it. And finally, the office and the applicant agree that this is what you invented, and this is what you're entitled to keep people out of and making. If that boundary stands scrutiny, then you've got a quality patent. But there might be things that we didn't know and mistakes that are made, and so.
Thanks.
Tom?
All right, let's give Russell a big round of applause.
Thank you.